Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the judgment of the Supreme Court on 2G scam. The judgment is important because it expands the legal right of a citizen as a complainant against corruption. To discuss the issue, I have with me Justice S.K. Agarwal, former Judge, Delhi High Court, and Mr. A.B. Dewan, Anil B. Dewan, Senior Advocate in the Supreme Court. Now for the headlines. The judgment expands the role of courts in relation to fight against corruption. The Supreme Court equates the right to set the criminal law in motion against a corrupt public official with a constitutional right. Subscribers may have to pay extra for number portability. 122 companies likely to suffer huge losses. Government likely to gain from fresh auctions. Now, a common man will have the right to file a public interest litigation complaint against a corrupt public servant directly in the Supreme Court if he has evidence to support his allegation. The Supreme Court sent a clear signal against corruption by cancelling all 122 telecom service licenses sanctioned by the then Telecom Minister A. Raja. The court also imposed hefty fines on companies that secured licenses illegally.
The Supreme Court first of all had to decide if a private complaint filed by Subramania Swamy was maintainable or not. The court not only answered the affirmative on this question, but went on to expand the right of citizen fighting corruption. The Supreme Court said that the right of private citizen to file a complaint against a corrupt public servant must be equated with his right to access the court in order to set criminal law in motion against a corrupt public service official. The right of access, a constitutional right, should not be burdened with unreasonable fetters.
One is that it recognizes the right of a private citizen to file a complaint for prosecution of a public servant. Two, it provides that if a public servant has ceased to hold the office which he is supposed to have misused, then notwithstanding the fact that he occupies another public office, he can still be prosecuted without sanction.
As per the implication of the judgment, all the 122 2G telecom licenses issued by the government will be cancelled, and the government will have to take a fresh call on auctions. The telecom regulator has to frame new recommendations for licenses and bandwidth allocation within a month. The fresh allocation of licenses will have to be complete within 4 months of the Supreme Court judgment. The Apex Court also imposed fines on those companies that secured licenses ranging from 50 lakhs to 5 crore rupees.
When the Supreme Court has said that whenever there is a natural resource or any form of government largesse which is being allotted to any private party, there can be no private negotiations. It has to be through a fair and transparent bidding process. Because in a fair and transparent bidding process, you can fetch the maximum amount because it is ultimately the gain to the public exchequer.
The Supreme Court also laid down strict timelines for getting sanctions against a corrupt public servant. All proposals for sanction must be decided within a period of 3 months of the receipt of proposal. In case consultation is required with the highest law officer, an extension of 1 month may be allowed subject to guidelines. If after this procedure, no decision is taken, sanction will be deemed to have been granted for prosecution. By cancelling 122 licenses in 2G spectrum case, Supreme Court once again assured its institutional integrity is not compromised in serving greater public interest. Now these companies will have to pay a hefty sum ranging from 5 crore rupees to 50 crore rupees.
Straight away to Senior Advocate Mr. Anil B. Dewan. So what's new in the judgment? What's the novel part?
The great thing is, for the first time, licenses have been cancelled, which means an enormous amount of loss for those who have made the investment. Why? Because the court has held two things. First, it was to favor certain parties. That means it's almost mala fide. Secondly, the court uses strong words like Raja, that is the respondent number 2, stage managed. They have used the word stage managed. What does it mean? Most importantly, I think people like us who have been fighting against corruption, because I did the Jain Hawala case, we are enthused that at least after so many years, after 14 years, Supreme Court has now struck an enormous blow in favor of good governance, in favor of controlling corruption, and most importantly, in spite of the huge amount of clout, both of government and the corporate sector, because the corporate sector is enormously involved. In spite of that, the court has stood by the citizen. It's like a tsunami. It's like a nuclear bomb.
I get it. I'll bring in Justice Agarwal. Justice Agarwal, the implication of this judgment on the trial that is happening in the lower court. Because if the Supreme Court goes ahead and takes a stand on corruption matters like 2G scam, does it leave any room for the trial court to go any other way?
No, the Supreme Court itself has said in the judgment, any observation made by the court will be free as to who were responsible, because in the trial, as you know it, large number of, there are politicians, there are bureaucrats, there are business executives, there are companies. Which person has what role will be determined on facts. It is not the observations of the court on the which is given on the basis of the documents that will determine the trial. Ultimately, what are the facts which they come before the trial court on the basis of the material that the prosecution is able to prove the ingredients of the offence, the trial court will be free. The Supreme Court has made an observation at the end.
So that, which means, I mean, this has happened not once but several times. Several times it has happened. But do you think it's as easy as said the way you're making it out to be? A trial court judge, okay, he's supposed to not get affected by the highest court of the land saying certain things about certain matters, and the trial continues on facts. Is it that easy?
No, it may not be that easy. That's right. But at the same time, the person who is holding a pen as the trial judge, he has to decide the case on merits. Whatever come before it, supposing the number of documents, the witnesses, the manner the witnesses are cross-examined, revealing the role of each person, to what extent the role of each person is there, whether there are more persons are involved or not. These are all questions of fact, which were not before the Supreme Court. Ultimately, the trial court, on the basis of the material that comes before the court, will have to decide in terms of the ingredients of the offence.
Right. So on the minute parts, it will happen. Bringing you, Mr. Devan, the point about equating the entire thing to the constitutional right of an individual to approach court and bring in law into motion. Corruption related, this right, specific to corruption, do you see the courts have gone ahead and expanded it, or it remains the same?
I think the locus standi remains the same. There is no expansion as such. The expansion is in the other case, not in the 2G case. In the other case, where it was held that Subramaniam Swamy can, as a private citizen, make a complaint directly. That's a separate issue. We are on the 2G scam issue. I think the locus was already there. People have approached. And I would like to agree with Justice Agarwal when he says that the trial court has been directed not to take into account this. So why do you assume that it will?
I get it.
And judges are trained to see, shut out things which are not relevant. So I think they will go on criminal culpability. Whether new documents may be there, new evidence may be recorded, so he will go strictly. So I don't think there is any great danger.
But on the Subramaniam Swamy thing, what was the expansion? Can you point out that expansion?
The question was not decided whether or not an individual can file a private complaint. That was the issue.
Okay. And
that was resisted by the government, but the judges have said, no, you can maintain it. That's the simple step ahead.
what does this allow an individual, a private citizen to do?
Basically, in the case...
The implication.
It's all right. Basically, what used to happen in the past was, in the cases requiring sanction, where the government's sanction against a bureaucrat or somebody holding the office is required, and some private citizen used to file a complaint, the courts will say, just no, shut it up, no inquiry, because it requires a sanction. First you investigate into it, get sanctioned it, only the court was prohibited from taking cognizance. That is what section 187 and 195 etc. talk about it. Here the situation is now it is allowed to prove the facts, and the question of sanction will then can be certainly applied for when the stage is reached.
Right.
This is what the difference between, I see the difference between the two.
Right. It's time for us to head into a break. When we come back, we will talk about the implication of the judgment.
It was not entertained at all.
Sanction will have to.
Sir,
sanction
one
is not
second.
given up.
Welcome back. Sir, you continue to talk and we, anyway. Okay. Play the bumper. Actually, welcome back. What is the implication of the judgment on various sections? Well, the subscribers of the 122 companies whose license have been cancelled will have to migrate to new companies within 4 months. This is likely to be an extra burden on the millions of subscribers. But for the government, there is likely to be gains as the new auction will generate higher license fee.
The companies whose licenses have been cancelled will have to move out of telecom business, as it is unlikely that the government will allow them to participate after facing severe strictures from the Supreme Court. Assets and properties created by the tainted companies will have to be sold to others to generate funds to pay off loans taken by them. The companies are expected to lose a collective sum of Rs 9,000 crores, which was paid as a license plus hefty fines imposed on them.
That the process by which these licenses were issued, for instance the timing of the applications, etc., that was also illegally changed to benefit certain persons. Therefore, the licenses have been held to be void and they have been cancelled by the court.
The judgment will affect 79 million customers for few months, but they will be able to make use of number portability facility to continue their services. But it is going to be difficult for the banks who lent 30,000 crores to these companies to bid for licenses. The companies like Airtel, Vodafone, Idea will benefit in terms of consumer shift, and the future 2G auctions may help them bridge spectrum shortage.
The impact of the judgment will lie in the consumer base of these cancelled license companies. These companies earlier offered call prices at very cheaper rates. Now these subscribers have to look for other companies and have to adopt the rates given by those companies.
But most important factor is these companies also should have realized while going for such a process that the process on the face of it appears to be rigged. If you are getting such an important natural resource at such a frivolous price, there was bound to be something wrong.
The 2G spectrum allocation scam came into picture in 2009 when Center for Public Interest Litigation and Dr. Subramanian Swamy filed a petition against the then Telecom Minister and Department of Telecom. As per the CAG report, the scam in spectrum allocations estimated 1.76 lakhs crores or losses for the government. Former Telecom Minister A. Raja is an accused in the 2G scam case and is facing trial in the matter. Raj Kamal, Rajya Sabha TV.
No doubt the government will be able to get higher license fee, but will it help in bringing down the communication charges for the consumers? Higher licensing fee will eventually be passed down to consumers. I want to bring it. There's a completely non-legal point here. There's always when the licenses are auctioned, huge bidding takes place, and there's huge amount of money that is generated for the government because everyone wants to get the spectrum. Eventually, the license fee that is going to be generated, or the company that pays that huge license fee during bidding, what happens to the consumer? Isn't it passed to the consumer eventually? So, for example, if you, me, or sir is watching, is using mobile, do you see that affecting the consumer?
See, much will depend on the response of the government, which has been given some time. It depends on the structuring of the terms and conditions. How you structure it, will you get more money? Now, one of the issues which have been raised is 2G becoming obsolete? Because 3 years have passed, 2008, 9, 10, 11. If that be so, will they bid at all? Because you have 3G, you may have 4G. So will there be detrol? Now this is one of the concerns. So the question is, when the TRAI or DOT comes back to the Supreme Court saying we propose to do this, at that time only things can be judged. I think it is too premature to say whether you'll get more or less. Much depends on what the conditions are, much depends on how they want to structure it, etc. I think we are going into an area where we have no sufficient data.
I'll get in, Justice Agarwal. That's perfectly all right. What you're saying is valid, sir, but there is clearly written in the judgment that public or national resource has to be auctioned at the best possible price. That's the implication. Eventually, they have trashed what was earlier provided and now trying to provide a new system so that the government gets the money which was also brought out by CAG. Given that parameter, is there any other way out other than the license fees going up? That we are sure that the license fee is going to go, the bidding is going to happen, it's going to go up. It's not going to go down. The implication on the consumer, that is what I want to bring out, sir.
You know, one thing historic about this judgment is, before I answer what you are raising, that it is for the first time that the Supreme Court has said, recognized, that the spectrum is a natural resource which is finite, scarce. If it is not used properly, or then it is bound to get degraded and all that. That is for the first time. Therefore, this being a natural resource, and the persons who are holding it, that means who are the government of the day, they are not required to distribute it arbitrarily, or say on the first come first served basis. This is what they have said. The Supreme Court has said that you do it auction in a transparent way. Now, what will be the effect of it is a question which we are talking in the air. We are a growing economy. When these cell phones were started, I do not know whether you remember it or not, the call rate was about 5 rupees per second or per minute. But today, you know, you have hardly 0.50. But that will not, it will depend upon nature, as Mr. Diwan has rightly said. Nature and the auction also can be subject to certain conditions. They'll create, the TRAI has been asked to give the paper, work out under what circumstances, so that the entire burden is not passed on to the consumer. But in a growing market like ours, I don't think so any consumer will in any way be affected. I'm very sure of it.
Okay, the second point, Mr. Diwan, that I wanted to clarify was monopolistic tendencies. There are not too many spectrum players. The companies that are there in India, it's in a handful of people who've already established players in this. This was one attempt, which was defense that was offered by former Telecom Minister A. Raja, that it will bring in new players and we will expand and broad base the companies or try and diminish the monopolistic tendencies that could emerge. Now, after this judgment, do you see it going back into the hands of the same players and the same players taking advantage of the spectrum and bidding for it?
I don't think so, because having more players is certainly an advantage to the consumer. As against that, what you are positing is that the players who have gone out, and those were the new players, will not bid again. The bidding will be only done by the older ones. Well, I am not sure of that, number one. Secondly, we are leaping in the dark. We don't know what the package which the government is going to offer. But two things I must highlight, which have escaped notice. First, this judgment says that if the auction route had been followed, the nation would have been enriched by thousands of crores. So first, the theory of no loss has gone for a 6. The theory of no loss cannot be consistent with this judgment, number one. Secondly, what people have missed is the Neera Radia incident. You now see why Neera Radia was so keen on having Raja. People have not made that connection. Why was Raja put to favor, to stage manage, and why was somebody else not permitted? So Neera Radia has played a very good role, which We are not on liability. We are on how the system is working. And this, I think, needs to be looked into. The role of putting in place a minister who has now stage managed, who has favored, and 3 companies. Immediately after the allocations were made, they got 24,900 crores of rupees.
Yes. On that note, it's time for us to head into a break. When we come back, we will show you an interview with Advocate Prashant Bhushan, who is part of the litigation. Welcome back. My colleague Raj Kamal spoke to Advocate Prashant Bhushan and tried to understand some of the highlights of the judgment.
So what are the key highlights of the judgment? What is the judgment all about?
What the judgment says is that the state cannot deal with valuable and scarce natural resources to give them to private companies by this method of first come, first served, which is prone to misuse, abuse, favoritism, etc. And that such a method of giving out scarce and valuable public resources to private entities is against, not only against the constitution, it is against public interest.
So the judgment says any private citizen can now file a complaint against any public official if he is involved in corruption. Does this increase the range of PILs now, sir?
No, the law on PILs had been settled long ago that any public spirited citizen can approach the court for either redressing the violation of the rights of disadvantaged sections of society or for redressing general public wrongs such as corruption, misuse of resources, environmental damage, etc.
The judgment suggests the government to review the section 19 of the CRPC Act. Could you please explain us in which context the judgment suggested this?
In the other judgment regarding the grant of prosecution sanction by the Prime Minister to Dr. Swami, they have said that look, normally so far as corruption is concerned, that should normally not require any prosecution sanction, but even if it does, there should be a time limit in that, and that time limit should be there in the law itself.
What are the major things involved in this judgment? Is it against government, or what is the judgment all about?
No, the importance of this judgment is to say that public resources, particularly natural resources such as minerals, spectrum, land, etc., which is there with the government, cannot be given out to private companies or private individuals for commercial purposes except through a transparent method of public auction.
A national resource can't be handed out in arbitrary manner, and auction is the only way to get the best price for it. I'll bring you in Justice, the sanction bit that Prashant Bhushan was talking of. This was delivered in Subramaniam Swamy part of the judgment. They've set a clear timeline, 1 month, 3 months, 4 months, only if this is involved 4 months. And there is no such timeline in the law. How is it going to play out?
That's right. You know, the law as it stood CRPC did not prescribe the sanction when the legislature framed the same. Obviously, you can't sit over for months together or years together, grant sanction, not to grant sanction. And that will be the violation of the fundamental rights of a citizen. So if somebody applies here to grant me sanction for the purpose of prosecuting, I am a government, I will sit over it. Therefore, the Supreme Court judgment is absolutely right. Now, the court is now laying down that the grant sanction, decide on it one way or the other within 3 months or within 1 month thereafter. And there, supposing that it is not done, then the citizen will have a right to approach the court.
Okay, that's the implication.
That's the implication by way of a writ petition or approaching the court to that this is my right is violated, because earlier law did not provide the time period.
Right.
You have applied it, they are considering it.
I get
they will take law as long as they want.
Your point of view on it?
I entirely agree with Justice Agarwal. And what they have done is they have picked out paragraph 58 of the Jain Hawala judgment or the Vineet Narayan judgment, which said that you have to strictly adhere to what we are saying, because there is a gap.
Yeah.
Now, that gap has to be filled up. As Justice Agarwal said, you have to exercise power within a reasonable time. And the court says this is a reasonable time. If you don't do it within that time, then you can have recourse for a mandamus or a direction, etc.
The point about one crucial point which we are missing out is about the foreign investments. You know the markets are expanding. This earlier Vodafone was a big, huge positive for foreign direct investment. But this judgment completely offsets the entire environment that the Supreme Court had created. The implications, Justice Agarwal.
I will say it will not affect. It is all transitory and temporary affair. As long as the nation is progressing, as long as the people in the world know that here is a law, has to be governed in accordance with the constitution, high or low, you cannot just bypass or approach or get the things done. It will enhance the image of the nation, and therefore, whether it is temporarily it will certainly not affect it. Rather, it will enhance the image, and better people will in the international market, the people have more faith in the country.
Mr. Dewan.
I think we are wrong. All over the world, people want good governance. What is this international covenant against corruption? It says that foreign companies, etc., ought not to indulge in things which are bad governance, which might give the odor of corruption. But I want to point out two things. One, we are discussing a judgment which was delivered on 31st of January, the second one on 2nd of February. Has the government accepted the judgment? That's a big question which nobody is discussing. Government has not said that we are accepting the judgment. It is possible that they might come up for a recall or for a review. It's for that they will make some political judgment and say, will this help us or will this not help us? So that's one very important thing which people are missing out on.
Right. Thank you, sir, for joining us on this discussion. It's time for us to end the show. You can email your suggestion and comments to law.rstv@gmail.com. You can also watch our shows on the YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.